Today, we're really opening up the legal operating manual for Canadian Charities. We're focusing on two absolutely foundational pillars, things that, well, underpin public trust and compliance. And this isn't just theory, right? We're talking about the actual rules deciding if a charity keeps its registration and if donors, get their tax receipts. Our mission here is to give you a really complete and hopefully fast grasp of the legal architecture, the structure, governing purpose, and, well, money flow in the Canadian nonprofit world. This means we're diving into some incredibly specific details, the kind that separates a compliant charity from one, frankly, facing penalties.
And that knowledge is just crucial. It's drawn from some essential readings on Canadian charity law, particularly those sections dealing with objects, ultra-vires, and receipts. These terms, they aren't just academic footnotes. They're really high-stakes governance issues that every single director needs to understand.
Okay, so let's start right at the beginning. The foundation of purpose. These aren't just, feel-good mission statements you put on a website. The legal objects of a charity, or the binding definition of its entire scope.
Yeah, they establish the absolute legal boundary for every single action the organization takes. You find them clearly defined in the governing documents. So that's letters patent, or articles of incorporation if it's a corporation, or maybe a trust deed if it's a trust. These documents, they literally define the organization's reason for being, legally speaking.
Okay, that brings us straight to that famous, or maybe infamous Latin term, ultra vires, acting beyond the powers. So if the charity is bound by these objects, what actually happens when a board maybe gets ambitious or wants to shift focus and they operate outside those specific stated purposes?
Right, that's where the severe risk comes into play. An ultra-virus action is basically any action taken outside the charity's explicit legal mandate. And the consequences, well, they're pretty far-reaching. First, any decisions or even contracts made while acting outside the objects, they can be declared legally null and void. That's a massive liability right there. Second, the Canada Revenue Agency, the CRA, they can, and they frequently do, revoke charitable status if they find resources have been used for purposes not listed in those foundational documents.
Wow. Okay, those first two are huge. Void contracts, losing your charitable registration altogether.
Yeah.
But what about the people involved, the board members themselves? Are they sort of shielded if they act with good intentions, thinking they're doing good work?
No, absolutely not shielded. That's the third major consequence: personal liability. Directors could actually face personal liability for authorizing actions that are deemed ultra-virus. If they spend charitable assets on an activity that isn't covered by the legal objects, they might personally be on the hook to replace those funds. It really underscores the difference between sort of doing good in a general sense and doing legal according to the charity's specific mandate.
Okay, let's make this really concrete. There's an example in the source material. Imagine a charity, and it has a very specific legal object.
Cool.
To relieve poverty by operating a community food bank. That's it. They get a large grant, a big donation, and the board decides, maybe with great intentions, to use the money to start a recreational soccer league for neighborhood youth. I mean, it certainly sounds beneficial, but does it actually fit that legal object?
It creates a major problem, legally speaking. The board might try to argue, that running a soccer league falls under that catch-all category of charity. The fourth recognized category, which is other purposes beneficial to the community.
But hang on, wouldn't the CRA look favorably on something that helps kids, promotes health, builds community engagement? Isn't that inherently charitable?
They might acknowledge the social benefit, sure, but they will look at the founding document first, every time. Since the charity's specific legal mandate is strictly limited to operating a community food bank, funding the soccer league is, well, outside that specific limited object. In this context, that specificity trumps the general catch-all category.
So even if everyone agrees the soccer league is a good thing for the community, it's likely ultra-virus because they use charitable assets for an activity not explicitly covered by the legal mandate the CRA approved.
Exactly. You have to be able to trace every single activity, every dollar spent, back to the specific language in the charity's founding documents. And just for context, those four recognized legal categories for charitable objects that the CRA and the courts use are 1. Relief of poverty, 2. Advancement of education, 3. Advancement of religion, and that fourth one, other purposes beneficial to the community, which is broad, yes, covering things from health promotion to advancing the arts, but it doesn't override a specific object. Really, the only way to protect yourself from that ultra-virus risk is getting those founding documents right from the very start. And that brings us to the next challenge, drafting the objects themselves.
Right, because there's this constant tension, isn't there? You can't be too broad. The source material warns that just saying to help people in need is way too vague. The CRA will just reject it. But if you draft it too narrowly, you box yourself in and force constant, really time-consuming and expensive amendments later on.
That's the tightrope walk, absolutely. And to combat that vagueness, the CRA has gotten incredibly prescriptive over the years, especially with their modern guidance, CG 019. It's no longer enough just to state the general mission. Each purpose now has to include a detailed activity description. They literally want the who, what, why, when, how, and how much for everything.
Wow. The legal gap between maybe some older charities language and modern compliance must be massive. Let's look at the contrast you mentioned, what the CRA expects now versus what might have been okay years ago. So if you submitted this today, vague, bad, to advance education in the community, that's basically going to be rejected almost immediately.
I know, certainly, yes. Yeah. It lacks any operational detail.
Okay, now here's the kind of detail the CRA requires today. It shows a massive difference in scope. Specific, good, as per CRA style. To advance education by providing structured, one-on-one after-school tutoring programs to low-income students aged 10-14 in the city of Toronto, with the goal of improving their literacy and math skills by one grade level within a school year.
You see the difference. That specific object defines the charity's entire universe of activity. If that organization suddenly decided, hey, let's fund a university scholarship program instead, they would immediately be acting ultra-vires, because their object specifies K to grade 8 level, structured tutoring in a specific city for specific ages. The scope is tightly defined, which, yes, protects the public interest, but it dramatically limits the organization's flexibility.
And if they do want to pivot, say they realize that actually Toronto kids really need better access to university funding, the process to change that object sounds absolutely grueling. It requires immense patience and a lot of time.
It really does. First, there's all the internal work, right? Drafting those new, incredibly detailed objects and activity descriptions. But then you have to submit a formal request to the CRA for pre-approval of the change, before you even file legally. And the source material highlights, due to significant backlogs at the CRA, this review alone can easily take 6 months, sometimes even longer. 6 months. Just to get permission to start changing the paperwork. That sounds like crippling bureaucratic friction, especially if needs change quickly.
It is a major factor, and only once the CRA formally approves the proposed change can the charity then proceed to the corporate step. That means filing articles of amendment with Corporations Canada or the provincial equivalent. And after that is finally done, you then have to file the final amended documents back with the CRA again. It really reinforces the idea that changing your core mission isn't something done quickly, in response to an emerging crisis. It requires months, potentially over a year, of planning and waiting.
Okay, so that sets the legal framework for what a charity can do, its purpose. Now, let's pivot to the second crucial pillar of compliance we wanted to cover. How you fund it. The objects dictate what you can do. The rules around donation receipts dictate how you raise the money to actually do it. Exactly. Issuing an official donation receipt is a powerful tax privilege granted to charities, but it comes with very strict legal limits. A receipt can only, and I mean only, be issued for a voluntary transfer of property by way of gift. The key phrase there is by way of gift. Legally, that means the donor receives little or no tangible benefit, or what the CRA calls an advantage, in return for their donation.
Right, and this is where compliance issues seem to crop up everywhere, because many common interactions between people and charities, things that feel like donations, simply aren't gifts in the eyes of the law. Let's maybe run through the list from the source material, the transactions that are absolutely disqualified from receiving a receipt.
Okay, let's start with probably the most common misunderstanding. Gifts of services. If a lawyer donates, say, 5 hours of pro bono legal work, or an accountant volunteers their time to do the books, no matter how valuable that time is, services are not legally considered property under the Income Tax Act, so no official donation receipt can be issued.
Wait, gifts of services? No receipt. That has to be the biggest misconception out there. People absolutely assume their valuable time or professional expertise is just as good as cash for receipting purposes.
And it is valuable to the charity, operationally, but it's not tax receivable property. That's the distinction. Similarly, a pledge, just a promise to donate in the future, isn't a gift yet because the property hasn't actually been transferred, needs to be in hand. And things like temporary use of assets, like loans of property, maybe lending equipment, or a lease of premises for cheap rent, or use of a timeshare, not a gift, because the charity doesn't gain ownership of the underlying property.
Okay, what about transactions where the donor is clearly getting something tangible back?
Right. If the donor has an expectation of return, it's generally not considered a gift, so that covers things like payment for a lottery ticket or buying a raffle ticket. You're buying a chance to win. If someone buys a book or a t-shirt or attends a workshop run by the charity, that's a purchase of goods or services. It's a commercial transaction, essentially, no receipt. Also, big one for events. Corporations that pay for an event sponsorship in exchange for, say, prominent advertising or logos everywhere. That's usually considered a business expense for the sponsor, not a donation.
That all makes logical sense when you frame it as no expectation of return. The last couple of items on the non-receivable list are interesting: court orders, membership fees, and gifts of promises.
Yeah, court-ordered transfers, say funds paid as part of a settlement or sentence, aren't voluntary, so not gifts. Membership fees are tricky. If the fee grants you significant benefits, maybe free access to exclusive events, publications, discounts, and the fair market value, FMV, of those benefits is calculated to be more than 80% of the fee amount, then none of the fee can be receipted as a donation. It's seen primarily as payment for those benefits. And gifts of promises, like a hotel donating a free night stay gift certificate they issued themselves. The property, the actual hotel stay service, hasn't been transferred yet. So the hotel donating the certificate doesn't get a receipt. The person using it might donate to the charity, but the issuer's promise isn't property yet.
Wow, okay. That list covers a huge amount of day-to-day activity and fundraising efforts. But now we hit what feels like the real complex math problem of charity law. Fundraising events like galas, golf tournaments, auctions, situations that often require split receipting.
Exactly. Split receipting comes into play because the CRA acknowledges that sometimes a donor might receive some value back, like a meal, a show, maybe a piece of art from an auction, but they genuinely intend the rest of their payment as a gift to the charity. The core principle is pretty straightforward conceptually. A receipt can only be issued for the amount of the payment that exceeds the calculated value of the benefit or advantage the donor receives. However, and this is critical, there's an absolute cutoff. If the value of that benefit is too large relative to the payment, the entire transaction gets disqualified from receiving any donation receipt.
And that absolute cutoff is defined by that critical 80% rule of thumb you mentioned earlier with memberships.
Precisely. It applies here too. If the fair market value, FMV, the realistic price someone would pay for just the benefit part, if that FMV is more than 80% of the total payment made by the donor, then no official donation receipt can be issued for any amount. That 80% threshold acts as a strict compliance tripwire.
Okay, let's really break that down. We need to look at the difference between getting it right and getting it wrong, using the gala ticket example from the source material. Scenario A, this is the compliant route. A ticket to the fundraising gala costs, say, $200. The charity carefully calculates the FMV of the meal and the entertainment, the advantage the donor receives, and determines it's worth $50. Okay, so since $50 is clearly less than $160, which is 80% of the $200 ticket price, the transaction is fine. The 80% rule isn't breached. So a receipt is issued for the eligible amount. $200 total paid minus the $50 benefit equals a $150 donation receipt. Clean, compliant.
Exactly. Now compare that to the compliance failure. Scenario B. The ticket still costs $200, but maybe this time the charity went a bit overboard on the advantage. Perhaps they hired a major celebrity performer, served an incredibly high-end meal, and the correctly calculated FMV of that advantage comes out to $180. Well, now Houston, we have a problem, because $180 is more than $160, 80% of $200. The 80% threshold has been breached. So the consequence: the charity cannot issue an official donation receipt for any amount, not even for the $20 difference.
Nothing at all. So the entire $200 is just treated purely as payment for attending the fancy event.
That's correct. From a tax receipt perspective, the gift portion is deemed negligible because the benefit portion was too high. That 80% rule completely changes the math. And miscalculating the FMV, or maybe ignoring that threshold, it doesn't just create potential compliance problems for the charity with the CRA. It also means providing misleading tax information to donors who might be expecting a receipt that isn't legally valid.
Okay, so stepping back and looking at the entire picture we've painted today, what does this all really mean? We've seen that these concepts that sound simple, like a charity's mission or making a donation, are actually rooted in extremely technical, very specific Canadian legal requirements. They're constrained by precise definitions of things like property, advantage, and these specific percentage thresholds.
Yeah, I think the essential knowledge distilled here is really twofold. First, the legal definition of purpose, found right there in black and white in those governing documents, is the ultimate constraint on all activity. Violating it through ultra-virus actions risks the entire organization's existence. And second, the privilege of issuing a donation receipt is strictly reserved for that voluntary transfer of properties, specifically excluding services, and also excluding any transaction where the advantage received back by the donor crosses that critical 80% threshold.
So whether you're maybe running a nonprofit yourself, thinking about joining a board, or even just deciding how to structure your personal support for an organization you care about, knowing these foundational rules, the purpose rules and the receipting rules, it helps protect that organization, it ensures compliance, and it helps confirm that charitable dollars are actually being used exactly where the law and likely the donors intend them to be used.
And maybe this leaves us with an important question for you, the listener, to consider. If the process for changing a charity's fundamental objects is so inherently slow, requiring potentially many months of CRA pre-approval before the corporate amendment process can even begin, what does that inherent bureaucratic friction truly imply about the ability of established charities to quickly adapt, to pivot their core mission, especially in response to rapidly changing or immediate community needs? Something to think about.